Thank you. I have a lot that I want to talk about. I'm very passionate about indigent defense. Does anybody have anything in particular that you're interested in hearing about? No? Okay. Okay. All right. Well, I'll start with a little bit about me. I am an Alpena native. I went to law school a little bit later. I got married young and had kids, and I was going to ACC, and I didn't think that law school was a possibility for me because of my situation. And Delilah Henry was my instructor for political science. I don't know if any of you remember Delilah Henry. He was one of my favorites, and he just kept saying, "You should go to law school. You should go to law school." And I said, "I can't. How am I going to do that? I have young children." And apparently he was aware that Thomas Cooley Law School had started a weekend option. So I went and took the LSAT, the law school admissions test, did very well on it. And Cooley actually accepted me into law school without a bachelor's degree. So I went straight from ACC to law school and started out on the weekends. And then I eventually moved down to the Lansing area for a few years and took the kids with me. And so I graduated in 2002. And then I later went back to Central Michigan University and got my bachelor's degree in 2012. So I did things kind of, and I didn't need to, but I wanted to. And I think it helped me with my career because my bachelor's is in public administration and community development. So I filled that little gap on my resume. And I was in private practice here in Alpena till about 2009-ish. And then I moved to Lansing for several years. I was in private practice there, worked for a friend of the court office in Clinton County. And then I moved to Grayling to accept a position with their court system. I was their court administrator and their family division referee. So in that position, I was responsible for all the courts in the county. And then I also got to put on the black robe and preside over hearings involving juvenile delinquency, abuse and neglect, custody, parenting time, child support. And then I was also the director of a 6-county regional sobriety court. And that was back when those were really getting going in the state. And so that was an interesting experience as well. And fast forward, I met my husband. Our children are all grown. We were ready for adventure. We moved to Missouri for a year. That didn't go so great. I mean, it was nice, but it wasn't Michigan. And then this opportunity came up. And so I moved back to accept this job in July of last year. So here I am. So indigent defense, goes all the way back to the Bill of Rights. And, rights of people charged with crimes, the way the court system operates, it goes back beyond the Bill of Rights. If you go into England and, the history back that far, but for purposes of what we do, kind of starts with the 4th, 5th, 6th, 8th amendments, which are all part of the Bill of Rights. And those amendments established they had to have probable cause for search warrants. There was a prohibition against unlawful search and seizure. There was a prohibition against double jeopardy. You can only be tried once. You could not be forced to incriminate yourself. You could not be deprived of life, liberty, or property without due process of law. You were entitled to a speedy public jury trial within the jurisdiction where the alleged crime was committed. And you couldn't be charged unless you were informed of the nature of the charges. You had the right to confront witnesses. You had the right to demand that witnesses come and testify on your behalf if they had something to say that would support you. And most importantly, you had the right to counsel. However, those only applied in the federal realm. So then along came the 14th Amendment, which then said, equal protection goes all the way to the states. So all of the things that you are afforded in the federal realm, you also have a right to in the states. Of course, a lot of the states didn't really jump all over that, and the Supreme Court had to get involved. And so then the Supreme Court comes along with Gideon versus Wainwright, and they specifically said the Sixth Amendment applies to the states through the 14th Amendment as to felonies. So that's when the states were required to provide court-appointed counsel to people charged with felonies. And then specifically, the court there talked about the vast sums of money that are spent on the machinery to bring charges against people. I mean, if you think about prosecutors' offices, all of the law enforcement agencies, all of the experts and the crime labs, and, you know, all of the resources that prosecutors have, and you would have defendants standing there by themselves with nobody to represent them when they were accused of crimes. So that was the start of it. And then, of course, the Michigan Constitution in 1963 incorporated a lot of the US Constitution, the Bill of Rights issues and things. And so then 1972 comes along, and there was another Supreme Court case, Argersinger versus Hamlin. And that one said, if you are going to be subject to any kind of incarceration, you have the right to have an attorney. So that extended that right to misdemeanors. And then finally, in 2002, there was a Supreme Court case. So, I mean, it's not that long ago that this is still developing. In 2002, there was Alabama versus Shelton. And this one said that you have the right to counsel even if you have a suspended jail sentence, which was huge. So let me step back a little bit. So felonies are the more serious charges. They generally, it's anything where you could potentially be sentenced to more than a year in jail. And there's some in-between stuff called high court misdemeanors, but for purposes of our discussion, if it's a year or less, it's considered a misdemeanor. If it's a year or more, it's considered a felony. So originally, only if you had the more serious charges could you get an attorney. And then they applied it to misdemeanors. So if you had a drunk driving, it was a 93-day misdemeanor. That means you could potentially be ordered to serve up to 93 days in jail. And so if the judge was potentially going to sentence you to jail, you'd be entitled to an attorney. Then the 2002 case came along and said, even if you're put on probation and your jail is suspended, which happens a lot, people are put on probation for a year and they'll have 30 days of jail suspended. So if they violate probation, they could be ordered to serve up to that 30 days. And that was the 2002 case. I said, oh, no, they have to have an attorney too. Just because you're not sending them to jail right now, if there's a chance that they could be incarcerated, that their liberty could be taken from them, they have to have an attorney. So that's kind of how we got to the point where, people have this right to counsel and what the framework for that is. So in Michigan, historically, it's been all over the place. There's been a couple public defender offices. Washtenaw County was one, and I did an externship there in law school, and it was a great office. And I think Muskegon County may have had one, but for the most part, indigent defendants, the attorneys that represented them were either on a fee schedule, so you'd sign up and you'd be on a roster, and you would get your cases, and if you went to a pretrial, you could get $20 for that case. And there was you check the box for what kind of hearing you went to. And if you had a status conference, it was this or that. If you had to go visit them at the jail, and so you would incrementally add up, and it wasn't very much money. Or there were like a flat contract, which is what Alpena did historically. And actually it was the whole circuit back when it was a 4-county circuit. And then when it went down to the 2-county circuit, they still continued that. So, Mike Lamble was in charge of that for many, many years. And so he would have a contract with the county for, say $150,000. And then he would do all of the criminal defense for indigent defendants. And the contract also included juvenile cases, probate cases where people had mental health petitions and they were being involuntarily hospitalized, they were entitled to an attorney as well. So his office was representing all these people in Alpena County, Montmorency County, Presque County, and Alcona County. And then when the circuit split, then it was just down to Alpena and Montmorency, which is what we cover now. So, and I mean, the 150,000, I just, I don't know exactly, you know, it's evolved over the years, what the annual contract was, but it wasn't a whole lot of money. And conflicts, you know, say you have co-defendants, you have people that were involved in an alleged crime together. Back then, that office would represent all of them. Well, you're not supposed to do that, but there weren't any resources to farm those cases out. There wasn't any money to pay anybody else because all the money was tied up in that contract. So the clients waived their conflict. They didn't have a choice. So they weren't getting quality representation on a lot of levels. There was assigned counsel, so people would be on the assigned counsel list, and the judges would decide who got assigned to what case. There were inexperienced attorneys generally got those contracts because the more experienced attorneys could bring in fees, they could get retained work. They didn't want that public defender work. Bad attorneys who couldn't attract clients ended up doing the contract work. There's a complete lack of oversight. Nobody was making sure that people were getting good representation. Nobody was making sure that attorneys were getting continuing legal education. Undue judicial and county influence. You know, there was an expectation that you're going to move the cases. You know, that's what we pay you for. Move these cases through. Get them out of here. You know, too many cases, 4 counties, 1 office, and no budget for experts or investigators to counter the expert testimony on the prosecution side. And then, of course, you factor in all of the prejudicial issues that have happened historically in the court system, the bias that people develop. So all of that led to the National Legal Aid and Defender Association doing a study in Michigan, and they generated a report in 2008, and it's called Race to the Bottom. Anybody ever heard of it? No? Okay, I'm going to send you links to this stuff. So I didn't want to send them ahead of time because I didn't want you to learn all about it and then be bored. So Race to the Bottom studied, I believe it was 10 counties in the state of Michigan and their indigent defense services, and Alpena was one of them. And they took a hard look at how indigent defense services were provided in Alpena County, and it wasn't pretty. So, I mean, we were one of the counties that was the impetus for getting this whole indigent defense thing going. So, I mean, it's a good thing that it, you know, got us to where we are now, but it's a very sad thing when you think about all of the people whose rights have not been properly, you know, observed and protected over the years. And it wasn't just Alpena, you know, I mean, it's a statewide issue, but Alpena had its own problems, and you can read that report if you'd like. So as a result of that report, there was an executive order signed by Governor Snyder in 2011, excuse me. He established the Michigan Indigent Defense Commission. And then the legislature passed the Michigan Indigent Defense Commission Act in 2013. So that permanently established the Indigent Defense Commission, and it set out a bunch of requirements, excuse me, for indigent defense in Michigan. So, and it's basically based on the 10 principles of an indigent defense system from the, let's pass some of those around, from the American Bar Association. There should be plenty there. And so this is kind of the roadmap for what we aspire to be. And so the Indigent Defense Commission got together and they looked at the ABA 10 principles, and they looked at the race to the bottom, and they looked at what other states were doing, and they started establishing standards. And there's 8 standards plus an indigency standard out there right now. 5 of the 8 have been approved, and 3 are in process. And then the indigency standard was just recently approved in 2021. So right now, the Michigan Indigent Defense Commission has the standards that are in place are education and training, initial interview, experts and investigators, counsel at first appearance, independence from the judiciary, and the indigency standard. Still in the works are limitations on attorney workloads, qualification and review of attorneys, and attorney compensation. So with the standards that are in place, there's a minimum standard for education and training. And we all have to get at least 12 hours of continuing education every year. And of course, we have to be attorneys in good standing, and we have to have experience in criminal cases, and we have to document our continuing legal education and keep the MIDC apprised of what we're doing. And they provide lots and lots of educational opportunities, which is amazing. Initial interview, when we get appointed to a case, we're required to interview the client within 3 days if they are incarcerated. This is huge because and I still see clients who aren't represented by our office, or maybe a juvenile client. They can go months without hearing from their attorney if they're in jail. They might get a letter, but their attorney won't go see them. They don't like going to the jail. And so we can't do that. Within 3 days, we have to be meeting with them if they're incarcerated. If they are not incarcerated, we have to initiate contact. So we have to send them a letter saying, I'm your court-appointed attorney, contact me for an appointment, try to call them, whatever it is. We have to initiate that contact. The third standard, experts and investigators, that gives us specifically earmarked funding to hire experts and investigators. And we now have 1 licensed investigator in the area, and we're soon to have a second one. And it's amazing, because when you get appointed to a case, you get the discovery from the prosecutor. So you get police reports, you get videos, you get witness statements, and that's what we have to go by. Well, now we can call up our investigator and say, we need you to go talk to these witnesses and see what they have to say. And just as a result of those interviews, we've had charges reduced, we've had charges dropped, we've won at trial, just by being able to do our own investigation. So it's been really amazing. And then, you get into the experts, and that's huge. So that's pretty amazing. And then the 4th standard, counsel at first appearance and other critical stages. Before the indigent defense requirements went into effect, attorneys did not have to be provided at arraignment. And arraignment is when you're first told what you're charged with. And it's important because it informs people of what they're charged with, but generally liberty is not at stake at arraignment. So that when I was the court administrator in Grayling, I did a workaround on that because I thought it wasn't a good use of the attorney's time. So anybody that was just walking in off the street because they had a summons to come to court and be arraigned on a new minor charge didn't have to have an attorney. But if they were in jail, they did for that arraignment, because all you did was read them the charges and you say, have you stand mute, enter a plea of not guilty on your behalf, and set the matter for the next hearing. So I understand what they're trying to do there, because in other places it's not as straightforward as that, but it's it's a requirement that attorneys are provided at first appearance. So we have Bill Pfeiffer is the arraignment attorney in our county, and then when others of us fill in if he's not available, but at every arraignment, he meets with every individual and explains their rights to them, and tells them a little bit about the process and stands next to him at arraignment. And then at every critical stage of the case, people have a right to counsel. So basically, it's all the way through, every court appearance, plea negotiation, of course, trial. And they really want us to have the same attorney representing people all the way through the process. And that seems like a no-brainer, but in the past, it hasn't been that way. It's whatever attorney shows up. And they do the cattle call thing out in the hallway at the courthouse, Mr. Miller, I'm your attorney today. And no meeting before court, no understanding of what's going on. So that's important as well. The Indigency Standard that was approved in 2021 is also very important. Traditionally, and we're still doing it here, if someone is qualified for appointed counsel, they're automatically charged at the end of their case. When they get sentenced, so if it's a misdemeanor, they get $250 tacked on to pay their attorney. And if it's a felony, they get $350 tacked on to pay their attorney. And this indigency standard requires a more in-depth look at their financial situation. And if they are truly determined to be indigent, then they don't have to pay anything. And if they're determined to be partially indigent, then you have to decide how much can they really afford to pay, and make it a little more fair. Because some people, a lot of people, their only income is Social Security or some other means tested income. They get paid once a month, and now on top of paying all their living expenses, they have to make a payment to the court to keep themselves out of jail. So our office is actually taking over the indigency assessments as of October 1st, because right now the court does it. And so we're going to do it. That's part of the independence from the judiciary. That is standard 5. So that the courts aren't deciding who gets an attorney. The courts aren't deciding what attorney people get. It just all comes to our office and we decide. The courts aren't employing the attorneys, so they don't have any supervisory authority over us. So, all that independence is really important, and it hasn't traditionally been that way. So that's kind of where we're at and how our office came to be. And most counties are moving that way toward a public defender office. There's county offices and there's independent. We're a nonprofit 501c3. So we're funded through the state and the county, but they don't have any oversight over us, which is great. And it just keeps getting better and better. I mean, MIDC is just so invested. We have a regional representative. Her name is Barb Klinszewski. She's got some relatives in the area, but she's out of Saginaw, and she's wonderful to work with. I mean, things as simple as putting a white noise machine in the interview rooms at the jail so that people outside the door can't hear our confidential conversations. It seems just like no-brainer stuff, but it's stuff that we've had to fight for these people. So I came back, and there's a board for our office, and they had done interviews for the chief defender, and Mr. Steigner and I both interviewed, and they decided that he had the trial experience because he had served as prosecutor up in Presqu'île. He had been actively practicing law where I had been working for the court system. And, while I was presiding over hearings, I wasn't advocating. But I had all the administrative experience. So they changed the structure a little bit. And now we have a chief and a deputy chief. So he's in charge of the attorneys, and I'm in charge of everything else. So I went out and found us an office. The building that we're in had just been gutted by the new owner, and I connected with him, and he thought that what we were doing was great. So he let me kind of design the layout of our building, and I kind of built it to suit. And we have I think we have a 5-year lease. And we love it there. And it was important to me. I don't know if you know where Mike Lamble's office was. It was Lamble and Bayat. They were on Chisholm, kind of across from Dairy Queen. There's that building that's Judy Trzynski's in there. The drug testing place was in there. I think it's next to Star Staffing. But anyway, it was well known as Lamble and Bayat. And if you needed a public defender, that's where you went. And we needed to, you know, disassociate ourselves with that address. And that was a battle because some people didn't want to. But I pushed for it, and now they're also much happier that we did. And so we've got our new office. We've got 4 attorneys on staff, Mr. Steiger, myself, Dennis Grinkovich, who was the prosecutor here in Alpena for a long time, and then Ron Bayat, who was actually one of the partners in Lamble and Bayat, has come on with us. And then we have 2 office staff, Chris Corwin, who worked for Lamble's office for many, many years as their office manager, and then Christy Plume, who was my secretary way back when I worked with Mike Mack and Dan White, and most recently worked at the circuit court for several years. So as soon as I got to town, I snatched her back, and Ed Black told me he had a bone to pick with me in the courtroom at motion day. Sorry. So that's our team, and we cover Alpena County and Montmorency County. We have a satellite office in Montmorency County. We staff it for about a half a day every 2 weeks, but it's also there for appointments with clients. And it's the first time in the history of providing indigent defense that the defenders have had a physical presence in Montmorency County. So it doesn't seem like it's that big of a deal that we have this little satellite office, but it's huge that, you know, people charged with a crime in Montmorency County have a place to go in their own county to get legal services. We do an annual grant application, it's a plan and budget, and ours has been approved for this year. Our budget for Alpena for 2023 is $775,000. And the county kicks in $165,000 of that. The rest of it comes from the state of Michigan. And it's actually less than the county spent when they contracted with Lamble's office previously, less than any county has spent, because the way they calculated that local share was based on spending from almost 20 years ago. And the Montmorency budget is $282,000 with a local share of only $17,000, and the state pays the rest. So we work within that budget. It's very specific on what it covers. You know, it's nice that we are a nonprofit. We're hoping to be able to partner with some local agencies, maybe some churches. I mean, I don't know yet. We still have to look into it, but it would be nice to be able to help with clothing for court. You know, maybe get like vouchers for the Salvation Army store, haircuts, things like that. Transportation, gas cards, taxi fare, just things like that. So those are things that we're still working on, and that's all part of what we call holistic defense, which is also kind of related to client-centered representation. And those are things that we are aspiring to and working on all the time. And actually this afternoon, we are interviewing for a social worker position in our office. And that is amazing that we're going to be able to have a social worker on staff. And that social worker will help with the intakes, help with that indigency analysis, and then they're going to triage our new clients. You know, do they need to be in substance abuse treatment? Do they need mental health treatment? Do they need housing? Do they need medical attention? Do they need to get their GED? Is there domestic violence going on in the home? Is it, you know, all of the things that contribute to criminal behavior? We're going to be able to start working on that right away, pre-trial. So while the person is waiting to get to trial, they're already going to be doing all of the things that they would generally be sentenced to do. They're going to be doing the counseling. They're going to be as prescribed, because we're going to have this social worker working with them. And then that person will also be our liaison with community mental health and behavioral health and Catholic Human Services and, corrections staff. And I mean, it's just so excited. And they will also be, represent us out in the community and be our outreach person. And then even more importantly, they're going to do what's called sentence mitigation. So they're going to take all this information from these people and they're going to write a report at sentencing and maybe testify, maybe not, and talk about all the reasons why that person shouldn't go to prison, even though there's a recommendation for prison, or why that person shouldn't get 12 months in jail. Maybe they should only get 6 months in jail. And it's going to be based on, what they're actually doing. It's going to be based on science. It's just, hopefully really going to help bring down incarceration in the area. And do some people deserve to go to prison? Absolutely. Do people deserve to go to jail? Of course. But when we start thinking about generally, and we'll say a man, mostly it's men that go to prison, unfortunately. I don't like to see anybody go to prison, but so he goes to prison and he loses his home, he loses his children, he probably loses his significant other if he's in prison for any length of time. We had a client whose mother passed away while he was in prison. He didn't get to say goodbye to his mother. People go to prison and they learn bad things from even worse people that are in prison. And you see that most in juvenile cases where juveniles are sent to lock up. We take an Alpena kid who's out getting in trouble and we send him to lock up down in Saginaw or Flint, or, just imagine the tricks that he's learning before he comes home. They're not getting appropriate treatment for their mental health. They're not getting, the tools to be able to reintegrate themselves into society when they get out. So then they reoffend, they end up with felonies on their record. And, well, we want you to stop breaking the law. You need to live a crime-free lifestyle. Can't get a place to live because you don't have any money, and you're not eligible for subsidized housing because you got a felony on your record. Can't get a job because you got a felony on your record. Or, if you've got some kind of a sex offense on your record, even if it's just a Romeo Juliet thing, now there's certain places where you can't live. Your name is out there for everybody to see. You're ostracized, from the community. You're turned down funding for education. What are you supposed to do when you're in that situation? And hopefully those are things that our social worker can help with by partnering with community corrections. And there's a lot more employers that are becoming more open to employing felons, especially if it's it's like a marijuana charge. You got a marijuana felony on your record from the 1990s. Should that keep you from getting a job? So all of that is still developing as well. But hopefully by bringing that social worker onto our staff, we're really going to be able to make an impact in that regard. Some other things that have been going on. There's a Michigan Joint Task Force on Jail and Pretrial Incarceration. They did a report in 2020, and they had help from the Pew Charitable Trusts. I don't know if you're familiar with them. They're on a national level, and they really put a lot of money and a lot of assistance into these kind of studies that really impact people. And then the Crime and Justice Institute out of Boston also assisted the task force. And they came out with all these recommendations, and that was back in 2020. And there's been a lot of changes to court rules, and there was a huge package in 2021 that changed a lot of laws, like driver's license suspensions. You used to be able to have your driver's license suspended if you didn't pay a ticket, or if you didn't pay your child support, or if you didn't show, all these non-driving related things. People would lose their license. Well, now how are they supposed to get to work? Especially here, there's not a reliable public transportation system, and you got some people that live out at the end of a dirt road, at the end of another dirt road out in Lachine, and they need to get to work at Taco Bell. And they lost their license because they couldn't pay a fine. So that's been addressed largely by this package of laws. They've decriminalized a lot of misdemeanors. They said, let's just make it a civil infraction, pay a fine, go about your business. It doesn't show up on your criminal record. There's no chance that you're going to go to jail. They've said that courts should be issuing summons and tickets. Law enforcement should be issuing tickets. Prosecutors should be requesting a summons instead of a warrant. The warrant is for arrest. So you get charged with a crime, prosecutor would swear out a warrant, and the cops would come and arrest you and take you to jail, and you'd have to post bond. And, they'd arrest you at work, they'd arrest you at home, they'd arrest you on the side of the road with your kids in the back seat of the car. And you got to go through this process and post, in a lot of cases, your $100 bond, and then appear in court. Well, they said, that's ridiculous. Just send the people a notice that says, here's your time to be in court, here's your appointment, show up. That package of bills put in place a presumption of probation for most misdemeanors. So now, if you get in trouble for a misdemeanor, a minor crime, there has to be good reason to sentence you to jail. Where there's judges that just automatically, oh, that's the charge, 30 days in jail, 60 days in jail. And now they have to put on the record a good reason to send a person to jail in those cases. And then another big one is they've reduced the maximum time that people can be on probation. Like felonies, it was 5 years. There used to be lifetime probation, and then they reduced it to 5 years, and now they've reduced it to 3 for felonies and 2 for misdemeanors. Usually it's a year, but it can be extended if the person is really not complying. But now the law says if you do everything you're supposed to do, you can get discharged from probation early at the halfway point. So now you've got people scrambling to get out there and get their shoplifters class done and get their impact weekend done for drunk driving or complete their counseling because they can get off probation early. There's a lot of studies that have shown the longer people are on probation, the more they're going to get caught up in the system for these technical violations. Oh, you drank last night, or you didn't show up for reporting, and it just, their probation gets extended, they get sentenced to jail, and their lives are disrupted, they lose their job. I mean, it's just a lot. So that package was huge. Now there is another movement kind of happening, and this is from a report from the National Center for State Courts. And that report is called The Future is Now, Decriminalization of Mental Illness. And that one came out in 2020. And I'm still waiting to see what's going to happen with it, because it's just something needs to happen. And we have, there's several residential homes for people who have mental issues, emotional issues, developmental disabilities, and the police will get called because they'll, somebody gets agitated and there's some kind of an altercation or they act out, and the police come and then they try to take this person into custody who has no understanding of what's going on, and they're scared to death. And so they're flailing around and they're trying to run away, resisting and obstructing. So now they're charged with a felony for resisting and obstructing police officer who's engaging in their lawful duties. And are they resisting and obstructing? Absolutely. Should they be charged? Absolutely not. And there's a lot of difference on how that should be approached. There's some police departments that are employing social workers, and they're sending social workers out on some of these charges. But then you've got the hardline law enforcement people that say it's too dangerous. Social workers shouldn't be responding to these kind of things. And then you've got, well, let's train the police officers in how to respond to these things. I'm a police officer, I'm not a social worker. So it gets very tricky on how to address that. I mean, it's very sad, and we've had so many cases, or even just the assault and battery charges, because when they get a violent conviction on their record, guess what? These homes don't want them. Then they have nowhere to go. So now they're in a homeless shelter, or they're on the street, or they're living with family that can't handle them. And what have we accomplished? That's the thing. That's the bottom line, is what are we trying to accomplish with all of it, with all of the criminal laws, with all the penalties, with rehabilitation, with indigent defense. I mean, what are we trying to accomplish? And believe it or not, it's very difficult to get all the players around the table and have them agree as to exactly what it is we're trying to accomplish. So in my position at this office, I'm really trying to influence all of the players and, you know, get them to come to the table and figure out some solutions and move us forward. I mean, when I was the court administrator in Grayling, we did a lot of innovative things, given the fact that we were one of the poorest counties in the state of Michigan, and other counties were really taking notice of what we were doing in it. And I had decided, you know, we're going to be a benchmark. We're going to be a benchmark for, of course, that was more juvenile back then, but for how, you know, juveniles are treated within the court system, especially in a rural court system within the state of Michigan. And that's what we just kept working toward. And now, you know, I want to go from being on that race to the bottom report to being the innovators when it comes to rural indigent defense systems. And that's what we're doing. That's what we're trying to do. Is to just keep things moving forward and keep improving the level of representation and keep making a difference in the lives not only of our clients, but their families, you know, making the community safer, you know, helping these people be productive members of society, stopping that cycle. You know, I'm representing adults that I represented as juveniles back in the early 2000s. I'm representing the children of people that I represented back in the early 2000s. You know, we want to try to, there's lots of places where we can definitely make a difference. So that's what I like to say. There's a lot of opportunity here. So I think that's about all that I've got. Anybody have any questions?
Did you say where your office is now?
Our office is at 503 North 2nd. It's on the corner.
The restaurant?
It is.
Oh.
It's on the corner of 2nd and Oldfield. It used to be the Old Town Cafe, North Side Restaurant. I think most recently the CIA restaurant.
Mhm.
And anybody wants to come and take a tour, stop by anytime. Be happy to show you around. We really like it. Looks nothing like it used to look. Yeah, that's where we are. Anybody else? Sure.
You mentioned your funding that you applied to the state for a grant, and that appears to be the major source of your funding is that state. Is that a competitive process or?
No, they are mandated. The state is mandated to fund indigent defense. So every county, every funding unit submits their plan for how
Okay.
they're going to do it
Okay,
in their county for that year.
see,
And it has to be in keeping with the standards. So if anything needs to be changed, they'll come back and tell us. You
so
can't
you're
do this.
documenting your process to qualify
Yeah.
for your share. And
Our
is-
share of the money.
Is that money then by formula to county or agency or flat rate or? what?
It comes to the county. So whatever we're approved for based on, you know, here's how much we're going to pay for our staff. Here's what our
Okay.
building costs. Here's
Okay.
what our supplies costs. You know, there's very specific categories. Then that money, it's all applied for by the county.
Okay.
And we're kind of a sub-recipient,
Okay.
but we still do the application.
Yeah.
So that money comes into the county and then the county pays us. So they add in their local share.
Yeah.
And they pay us. And then whatever we don't use gets applied to our next year's budget.
Your client fees, you mentioned the 250 or whatever, that
We don't get that.
you don't get that.
No.
but you determine whether it applies or not.
Well, no. No, the court does. Like right now, the court determines who's indigent and, you know, who qualifies for court-appointed counsel.
Okay.
And then they assess that fee at sentencing. And going forward, as of October 1st, we will be making the indigency determination, and we're trying to get the counties to agree that they're just not going to assess that anymore. We don't want it assessed at all,
Okay.
unless there's, you know, evidence that somebody can really afford to pay it, because you know, if you get convicted of a misdemeanor, there's a $50 justice system assessment.
Okay.
There's a $75 crime victims' rights assessment, has to be assessed, it's a state fee, goes into a state fund. There's a fine, which I was gonna say Judge Hunter, but that's not Judge, Judge Curtis has really been fair with fines and costs since he's been on the bench. So you might get a fine of $150, cost of $150. So now you're up to $350, $425. And you've got probation oversight fees of $20 a month. So if you get put on probation for 6 months, then there's another $120. And then you get the attorney fee, that's $250. And then if you have some kind of a charge where the prosecutor or the police want restitution, that could be another $100, $200. And if there's actual restitution because you've damaged somebody's property, you know, so I mean, these people are walking out of court with $1,000 assessment. They might not be going to jail, but now they're on the hook for $1,000. And, you know, they make $772 a month, and where are they supposed to get the money? So, yeah, we would like to do away with that. The problem is, and I, being from the court side of it previously, the county uses that money, I'm sure they do, to help cover the cost of the contracts with attorneys on the juvenile side, because we don't do juvenile yet. There's just been a new report that recommends that juveniles be brought under the MIDC umbrella, which I am so happy about. We'll see how long it takes, but so those are private attorneys, and there's no special funding. I mean, there's a little bit, but so the juvenile attorneys, the abuse and neglect attorneys, when kids have their kids, or when people have their kids taken away, those contracts have to be covered. The mental health contracts, none of that is covered by MIDC. So, you know, they're using that revenue, I'm sure, to help pay for that. So it's going to be a little painful for them to let it go, but we're going to keep pushing.
I just have a comment from my perspective is the thing that caught my attention is the use of the word indigent, which I think a lot of people have a preconception or a conception that's different than the way you're using and in this system. In other words, indigent is almost the preconception is homeless, hobo-y, something, doesn't have a job, doesn't have anything. That's I think, at least my preconception of that word. And so it's, I mean, I understand the concept and everything you're talking about, but the word itself just caused me to step back a little bit and say, well, don't you cover this, you know, people that have a job, people that have things, but they can't afford
Yes.
an attorney. So that's just my comment is I think that word, or the use of that word, at least to me and maybe other people, causes some kind of a bias reaction in their head when they hear that word. That's just a comment, nothing.
Yeah, I could see that. But that's not necessarily always, I mean, there's people that work full time that still qualify, which is a good thing.
Is your office able to help your clients expunge their previous records? I mean, you know, remove certain crimes from their record?
Not at this time. We are limited only to the actual criminal case itself. So once they're sentenced, unless they have a probation violation, we're done. If there's an appeal, that gets sent out to court-appointed appellate attorneys, unless it's what's called an interlocutory appeal, which is an appeal that's in the middle of the case. So we don't do expungements. We don't help them get their driver's license back. That's a civil proceeding through the Secretary of State. There is an expungement clinic coming up. And I wanted to help with that, but unfortunately I'm going to be out of town. And I had actually talked with a couple friends of mine who are private attorneys previously and said we should do this, just on a volunteer basis because people don't understand the process. Michigan Works has some funding for that and they contract with one attorney, but there's such a backlog right now that it's not getting done, but that's huge, especially since they've changed the law where, you can have more convictions expunged. I wish that we could, and I kind of off the record, I might print out some forms and give somebody some advice about the process. I can't represent them in that process. And maybe someday that will change as well. And that's part of that whole holistic approach. We want to help them with everything.
Any other questions?
On. Okay. When our police are called out now to a domestic or mental illness breakdown or something like that, is there a team now that goes with them, or is it just the police, and are our police trained in any way to handle this?
There is not a team. And some are, some aren't. I'm not sure. State police tries to provide training that's, kind of up to the moment as far as what's going on, but they're also one of the most regimented agencies where, I'm a police officer, I'm not a social worker. So I know in Crawford County, where I worked for the court, that sheriff's office was very progressive in making sure that deputies were trained, especially like dealing with autistic kids.
Yeah.
If you come upon an accident and you've got an autistic kid in the car and you're trying to get him out of the car, what do you do? And they even, put out stickers for people to put on the car, just to like a little coded thing to say, this is an autistic child. And I thought that was great. And, I'm hoping to talk with our new sheriff and get some things rolling at our sheriff's department as soon as they get their staffing issues leveled out. They've had a lot of problems with shortage, and then of course the city police as well. So to make a short answer long, I don't know if they have training. In my experience with the cases that we've seen, I haven't seen any evidence of any specialized training as far as like de-escalation or that triage kind of process.
Your office was a social worker.
Yes.
Is that really going to be enough?
Well, we'll see. If we,
It's a start.
yeah,
That's true.
if we end up with a master's level, then we can do
Yes.
internships. So then we can, get some extra help that way. Or if we need more, the thing is I don't know where they're getting the money. But MIDC they hardly ever say no. And part of this all came out because of a big lawsuit, which is usually how this stuff comes about anyway. But the commission was a response to a lawsuit that was dismissed because the state promised. So if the state starts reneging on anything, back comes the lawsuit. So yeah, job security.
Okay, any other questions? Well, thank you so much for joining us today. Really
Thank you.
appreciate you being here, your expertise and sharing all of that with us. Thank you very much.
Thank you.